There are two different types of annulment, a civil annulment and a religious annulment. Courts issue civil annulments. A civil annulment may not be required to obtain a religious annulment. If you are married in a religious ceremony, you should consult with your clergy person concerning the requirements of obtaining a religious annulment. Many people misunderstand civil annulments. In New York, there is little difference between an annulment and a divorce. Both end the marriage. Many people mistakenly think that when a marriage is annulled, the marriage records are destroyed. Just as in a divorce, the marriage records remain on file. Another misconception is that an annulment can be obtained solely based upon being married for a short period of time. This is not true. Once parties marry, they are married. The law does not provide for a trial marriage. Many people think that an annulment is simpler than a divorce. This is also not true. An annulment is actually a bit more complicated than a divorce, and as a result, generally costs more to obtain. The main benefit of an annulment over a divorce is that since most people think less negatively about an annulment provides a psychological benefit to the person obtaining the annulment. Also, if the person meets another person that he or she is interested in, most likely that person will also think less negatively about the person if he or she received an annulment rather than a divorce. The legal action to declare a marriage annulled is brought in the Supreme Court of New York. In New York, the Supreme Court is not the highest court or even an appellate court. It is the court of general jurisdiction. There are two different types of marriages that can be annulled: void marriages and voidable marriages. A void marriage is void at its inception and as a result can never be made legal. Examples of void marriages include a marriage between an ancestor and a descendant, such as between a parent and a child, a marriage between siblings, a marriage between an uncle and his niece, or an aunt and her nephew. In New York, cousins may legally marry. Other examples of void marriages include a marriage terminated or dissolved and whose spouse is still alive, and a marriage performed by someone who did not have the legal authority to perform the marriage. Although a void marriage is not recognized as valid, such a marriage cannot be legally terminated without obtaining a declaration of a nullity of the marriage. In addition to the declaration, the court can also legitimize children of the marriage and address all issues of the marriage, such as custody of the children, child support, maintenance, and equitable distribution. Voidable marriages are marriages that, although legal at inception, can be annulled if any of the following conditions are met. Either spouse was incurably unable to have sexual intercourse at the time of the marriage. After marriage, either partner becomes incurably insane for 5 years or more. The court may include in such an annulment judgment a provision that provides suitable support, care, and maintenance of the disabled spouse for life, payable from the property or income of the non-disabled spouse. A marriage involving a person younger than 18 may be annulled at the discretion of the court if the spouse who is under 18 wants an annulment. The annulment will not be granted if the minor cohabited freely with the other party after reaching the age of 18. Either spouse was unable to understand the nature, effect, and consequences of the contract of marriage because of mental incapacity to either mental illness or mental retardation. Either spouse consented to marry as a result of force or duress by the other, or consent to marry was obtained by fraud that would have deceived an ordinary prudent person and was material to obtaining the other spouse's consent. The fraud must go to the essence of the marriage contract. Concealment of a material fact may constitute fraud. A legal action is also required to annul a voidable marriage. Only the spouse not at fault may commence the action to annul. An annulment requires a higher degree of proof than a divorce. Often, corroborative evidence from other witnesses is required to establish the proper grounds. Strict time limits apply to commencing the annulment action. Each of the reasons for an annulment may also contain further restrictions. The vast majority of annulments are based upon fraud. Fraudulent acts that warrant an annulment include marriage for a green card, falsely claiming the desire to have children, falsely claiming to love the other spouse, and falsely claiming to be pregnant. Proving an annulment case will require an affidavit from a witness who heard the spouse make a statement prior to marriage that was false, and then after the marriage heard the spouse admit that the false statement was made prior to the marriage to induce the innocent spouse to marry. My name is Jeffrey Peltz. Over the past 25 plus years, I've helped thousands of clients with family law matters. I invite you to look through our website for more information on annulment and our law firm. When you're ready for more information, call us toll-free at 855-625-0800 to schedule a free consultation either by telephone, video, or in our office.